afternoon. Good morning, everyone, and thanks for joining us here today. My name is Carolina Albernas. I'm Director of Business Development Operations at the Brazil-Canada Chamber of Commerce, and we're here today for another episode of the Brazil-Canada Talks to talk about hardship, force majeure, and judicial recuperation, hot topics in Brazilian business law. A few housekeeping rules. After the presentation, we have a Q&A session with the panelists, so if you have any questions, please add them at the Q&A box during the webinar, and we'll answer in the end. So first, for those who are not familiar with the BCCC, for 47 years, we've been building relationships between Brazil and Canada, strengthening the bilateral relationship in investment, trade, best practices, and mutual growth and prosperity. Our relationships are private and public, featuring the managing directors and decision makers from small, large, and very large companies and institutions. Our volunteer board of directors is comprised of many business executives with expertise, knowledge, and connections that can only be found by being very active players in the Brazil-Canada market. We are a membership-based association, and we support our members through advocacy and government access, as well as qualified information and insights and connectivity. Our network is unparalleled, with access to universities, not-for-profits, and C-suite executives, entrepreneurs conducting business between Brazil and Canada. So if you are interested in learning a little bit more about the BCCC, please do not hesitate and contact me. We'll be happy to connect you after this webinar. We are here today with our friends from Rossi Watanabe, Baker McKenzie, to discuss the concept of hardship and force majeure in Brazil and the effects on corporate contracts, as well as how foreign investors are dealing with those topics in Brazil. Also related issues that are consequences of the economic crisis caused by the COVID-19 pandemic. So without further ado, I would like to introduce our panelists today, Joaquim Muniz, Giuliana Schunck, and Gledson Campos, partners at Rossi Watanabe. So thank you for availability to speak with us today, and I'll pass the mic to, I guess, Joaquim. Thank you so much.
First of all, I'd like to thank BCCC to host us. Since this COVID-19 crisis, we have been seeing a lot of issues arising to our clients. I would like to share with you some of the legal discussions that we are having under Brazilian law. So we're going to start with my partner, Giuliana Schunck, who has a PhD, and her thesis it's based on hardship, to speak a little bit of how is hardship and force majeure under Brazilian law, and how it differs from other jurisdictions like Canada. Then I'll speak a little bit about how courts are deciding force majeure and hardship case in Brazil now, both judicial courts and arbitration courts. All these crises are adversely affecting Brazilian companies. So we see a big rise in requests for judicial recuperation. That's a Brazilian equivalent to Chapter 11. So also brought our partner Gledson Campos to speak a little bit about those institutes, because your company might be creditors of those companies under financial distress. So without further ado, I pass the floor to Giuliana to start our presentation. Thank you for your attendance.
Thank you, Joaquim. It's a pleasure to be here today with you. Thank you, Carolina and BCCC for the invitation. It's really nice to have this opportunity to talk to you. So my whole here today is to talk a little bit with you about force majeure and hardship under Brazilian law. So I share a presentation with you. Just a second here. It's here. Yeah. So we will talk a little bit about the effects of the pandemic in contracts under Brazilian law. And basically, before starting those topics, it's important just to have a brief a comment here briefly with you that Brazil is a civil law country. So for those who are not familiar with Brazilian law, we are a civil law country. We have a civil code, which is applicable to all private contracts, except for consumer law. We have a separate consumer code. and contracts with the government, with the public administration, which still is governed by the civil law, but only with residual application, only when the specific laws are silent. So having this in mind, and we have the concept of force majeure in our civil code, which is Article 393 of the code. And we know that the pandemic affected a lot all the countries, and many companies were, especially at the beginning of the pandemic, and all the effects with the forced isolation and lockdown we had. We know that many companies were worried about the effects of the pandemic in the contracts and how force majeure would apply. And we had, especially in our practice, we had lots of clients that came to us and wanted to allege force majeure, were very concerned that the other contracting party would allege force majeure. But what we see in terms of force majeure, in fact, indeed in Brazil, force majeure applies to all contracts. But of course, we have to analyze if it's indeed a case of force majeure, if the theory, the doctrine of force majeure would be applicable to that specific event. Because the pandemic itself can be an event of force majeure or cannot be an event of force majeure, depending on how it affects that specific contract. So in order for us to be able to analyze if it's the case and one of the contracting parties may be allowed to allege force majeure, we need to first understand how that specific obligation of that contracting party would be affected by the pandemic or any of the pandemic effects. So the most important thing we need to analyze is if the obligation is completely impossible to be complied by the contracting party. If not, then we will be in a position not to allege force majeure, and we may be in a position to allege one of the other doctrines that could be applicable here specifically to the effects we will see in some moments. So if we have an obligation that cannot indeed be complied with by that specific contracting party, then we can be in a force majeure scenario. And what happens if the contracting party can indeed allege force majeure? Then we will be in a position where we will, the contracting party will be exempted from not performing the obligation. So the obligation will not be performed and the contracting party will be completely exempted, will not be in a position to pay contractual penalties or be responsible for damages in general. Because here in Brazil, when we have a default by the contracting party, this default automatically leads to the payment of damages, if applicable. Of course, the other party needs to prove the damages that were suffered in view of the default. Also, possible contractual penalties that might be set forth in that specific agreement. So that is basically, those are the consequences of the application of force majeure. So the contracting party that needs to perform that specific obligation will be exempted, completely exempted from the performance without any of the natural consequences which would be damages, penalties, etc. But it's also important to remember, and this is a normal mistake that we see clients many times making, to consider that the force majeure would automatically terminate the agreement. that is not true. It may terminate the agreement if we are talking about only one specific obligation, or some specific obligations that are set forth in the agreement, and all those obligations are exempted in view of force majeure. If we analyze what is happening right now in terms of the COVID-19 pandemic, it would be rare to see the termination of agreements. Only if we are facing very quick agreements that have only certain limited number of obligations, so that we can imagine 3-4 obligations during these specific pandemic times that cannot be complied with, that cannot be performed. If we talk about long-term agreements, such as lease agreements or distribution agreement or even construction agreements, force majeure will only exempt the performance of those specific obligations that occur during the time that force majeure was being observed. So normally it will not be the case to completely terminate the agreement. We also have here, and let me change the page, the theory of hardship, or the doctrine of the change of circumstances and enforceability doctrine. It's wrong here, sorry, it was the enforceable doctrine. So we talk about here those circumstances that cannot be known by the party, that are completely supervenient to the signing of the contract, to the execution of the contract, and that happen afterwards during the period that the parties are performing their obligations. So let's imagine that we have a change of circumstance that is really material to the party and that brings an excessive burden, a very difficult situation to comply, to perform that specific obligation. If those circumstances happen, we can here in Brazil allege the theory of hardship, or the doctrine of enforceability, those events that are completely unknown. As I told you, we have here a civil code, so even if the parties do not decide to mention anything considering this in their specific contracts, both force majeure and hardship will, and other doctrines that are in our civil code, will automatically apply. So even if the contract is completely silent, hardship will apply if the requirements that we have in our law are met. And which requirements we are talking about here? The requirements are set forth in Articles 478 and the following ones of our Brazilian code. So in order for hardship to be alleged by one of the parties, we need to be facing a long-term contract or a contract with deferred obligations. So differently from force majeure, that can be applicable to all kinds of contracts, in order for hardship to be applicable, we need to be in front of a long-term contract. This is very important. Or a contract with an obligation that is to be performed within some time, so it's not an instant contract. We also need to be in front of a situation that will bring excessive burden to that contracting party, which was the debtor of that specific obligation. So the obligation can still be performed. This is different from the force majeure as well. It's not completely impossibility, it's just an excessive burden, a very difficult situation for the performance, but it can, in practical terms, it can be performed by the debtor. And we need to be also facing enforceability, unknown, unexpected events. So it's not possible for the party to allege hardship or the doctrine of enforceability if we are facing events that could be known, could be expected by the parties before or at the time the agreement was executed. The unforeseeable or unexpected event, as I told you, does not prevent the compliance with the contract, with the obligation, but it's very hard to be performed. The obligation becomes, the compliance with the obligation becomes very hard, and the unexpected event modifies the economic balance of the obligations of the party, the economic balance of the contract per se. And if we are, if all those requirements are met, the party that is facing this hardship can request the renegotiation of the agreement and the review of the agreement. The review can be made upon renegotiation, private renegotiations of the parties, or if the negotiations fail and the debtor cannot change the agreement and change the obligation in private negotiations, it can go to court and can try to review the agreement in court. The Brazilian law does not authorize the review of the agreement in courts expressly, but the Brazilian doctrine and our case law, our court precedents, and our commentators, they allow the parties to go to court to seek the review of the agreement. So it's all possible to have the request in court, either to have the agreement terminated, because this is what our civil code expressly sets forth, or to have the agreement reviewed. And in Brazil, it's important also to mention that we have the good faith principle. That is a principle that shall be observed by the contracting parties. It's a conduct of the parties to maintain a very the same behavior, let's say so, during all the moment the contract is being performed. And because of the good faith principle, we have a duty to renegotiate. It's not set forth in law, but it is considered by our commentators, by our case law, that the parties shall, especially in long-term contracts, the parties shall renegotiate. And as I was telling you, if the parties fail to renegotiate in good terms, that party that is the aggrieved party, the party that is suffering with the hardship situation, can go to court and ask the review of the agreement. And in this specific point, it's important to mention that the review of the agreement in court, although it is completely authorized and the party may take that discussion to court, it may lead to some situations that are somehow inconvenient, because the party will be in a position to have the review of the contract made by the judge, and the judge is not bound by the specific request of that party. The judge will need to consider also what the judge needs, the judge feels that is the most appropriate review. And to do that, most of the time, they just don't know how to contract, how to review contracts. They are not experts in that specific business, in that specific industry of the parties. And due to that, we sometimes see judges that determine expert investigation to occur to verify if the request for the review is adequate, if the price that is being offered is reasonable in terms of what needs to be reviewed, if for the parameters, the standards of and the principles of that specific industry that would make sense. So in the end of the day, it's not unusual to have requests of judicial review to be, even if they are granted, sometimes they are granted not in the specific terms that the plaintiff required in court. They are granted in other terms, in other formats that can be determined by an expert that will be appointed by the judge. So although it's all possible for the aggrieved party to seek the judicial review or even the review by means of arbitration, it's important for us to remember that judges, especially judges, because arbitrators will be at least more careful, and Joaquim may talk about that in a while, but judges will have the assistance of experts in that field. That's all common. And the party may have a decision that's not exactly what it wanted and what it envisioned for the case. So that's something that we always discuss with the clients, that it's important to renegotiate, to privately renegotiate, to try to reach common grounds. And sometimes it's better to be more flexible in terms of reaching common grounds, because once the party decides to go to court, it somehow loses a little bit of the power to really have the best renegotiation, because the power will be with the judge. The judge is not an expert in that field, so it's very usual to have expert investigation and the judge appointing an expert in that industry. And the final word, let's say so, may be the word of the expert that was appointed by the judge, and we never know if the expert is indeed a good expert, what are the characteristics, the profile of the expert. So it's important to have this in mind before really deciding to go to court and to escalate and to somehow lose the control of the negotiations. We also have in Brazil the doctrine of the changes in the basis of the agreement, which is a theory that comes from the German law. It's not in our civil code. It's a more flexible doctrine that is allowed and considered by our commentators, but it's being applied as well. It's called in Portuguese modificação, a quebra da base do negócio jurídico. So the changes or the violation in the basis of the agreement, and it's being applied as well during these pandemic times, because it's a more flexible theory, and it does not need to have all the requirements that I mentioned to you of the hardship theory that are fixed requirements set forth in our civil code, and needs to be really addressed and observed to allow the theory, the hardship theory, to be applied by the judge. So this theory, that is the change of the basis or the violation of the basis of the contract, is being applied as well during the pandemic times. It's a more flexible theory with the same roots, let's say so, of the hardship, but more flexible. It only needs that the obligation of the parties, of the contracting parties, or specifically the obligation of that aggrieved party, the debtor that cannot perform its obligation, his, her, or its obligation because of the change in the circumstances, So that party alleges that there was a violation in the basis in what the parties agreed for to the and expected for to be the basis of the agreement, and this may be also an alternative in order for the party to try to renegotiate that specific obligation. So as you can see in Brazil, differently from other jurisdictions, especially English law and other laws, we have means to renegotiate the agreement, and the Brazilian Civil Code contains specific provisions for the review of the agreement or the termination if it's applicable. But in any case, it's important for the parties to be very cautious in terms of trying to renegotiate privately, trying to address the duty to renegotiate, as we know we have in other soft laws, as we have in the UNIDROIT principles, as we have in the European principles of contract law. Although we don't have this specific renegotiation principle in our civil code, it's really applicable in Brazil because of the hardship theory that we have in the civil code, and also because of the good faith principle. So although we know it's possible to discuss and to take those disputes to court, we are very cautious when we discuss and when we analyze situations similar to that with our clients, because we know that taking those things to court or even to arbitration may not be the best option. So I think Joaquim can comment a little bit further in terms of arbitration now. So Joaquim, please feel free if you want to make your comments.
Thank you, Giuliana. It's very interesting because it makes a lot of difference if you go to arbitration or to judicial courts to discuss those issues. And we are seeing a lot of discussions in both venues. You have to bear in mind that litigation strategy in this kind of issue has both a short-term and a long-term perspective. The short term, because normally you need an injunction, for instance, to declare force majeure or to stop performance of an agreement that is subject to hardship. In the long term, we have the ultimate decision of the court. So short term in Brazil, the Brazilian lawyers know judges usually judge quite quickly requests for injunctions. So we are seeing case law on injunctions right now, but the definitive decisions on those issues will take like 5 to 10 years. Those issues are also being brought to arbitration, but most Brazilian arbitration chambers don't have emergency arbitrators. So they are likewise being sent to judicial courts, because before the formation of the arbitration tribunal, the party, according to Brazilian Constitution, Article 5, Item 35, can go to judicial court, and then after the arbitration tribunal is constituted, the issue is sent back to the arbitrators to decide. So mostly the case law that you see right now are court decisions. In the long term, if you go to judicial courts, it's going to have some kind of decision, and I believe that if you go to arbitration, the decision might be different, and I'll explain why. But let's start with the short terms, that the battle of injunctions at the courts that we're living right now. Like, it has been a very busy time for litigation lawyers in Brazil, trying to get injunctions to declare force majeure or hardship. What we see right now is that the decisions are quite contradictory and are very fact specific. We have cases, for instance, most of the cases are either for lease agreements or agreements, continuous agreements like power purchase agreements. And we see courts granting sometimes those injunctions, for instance, to allow reduction of rent of offices that are not being occupied, or reduce values of power purchase agreements. But on the other hand, in other instances, some courts deny. And I believe that those decisions are right now mostly based on the facts of the case and whether or not the party is acting in good faith, or on the opposite direction, if the parties, the claimant, the plaintiff, in this case, the plaintiff is acting with rent-seeking, like opportunistic behavior. So it's very, since I have an audience of businessmen, my strong advice right now is to document your position. What I would recommend you to do, like if there's a risk that someone that you are dealing with will claim force majeure, and Giuliana explained that force majeure is pretty much based on the impossibility to perform. If you're claiming force majeure, you have to send notice, have minutes of meetings showing that it's impossible for you to perform. But if you're in the opposite direction, you are the one that bears the risk of getting an injunction declaring force majeure. Try to answer the notices and be very careful with minutes of meeting to show that the obligation is not impossible to be performed. So contract management is key right now for the short term. The same thing with hardship. The party will say that's very onerous, but to get a classical case of ownership, you have to show that somehow the defendant is benefiting. So if you are the plaintiff, you have to put in the record, like through notices, emails, minutes of meetings, that the obligation became too onerous. But if you're on the other side, like if you are the defendant, it's important that you answer the message saying like it might be onerous for you, but it's also onerous for me. Like I'm also being hurt. It's very typical. I'll get to those two most popular, let me call it this way, cases. First, like rent. If and that links back to what Giuliana just said about the duty of good faith under Brazilian law. Like if you show that you are acting in good faith, like the landlord, and saying like, I'm giving you a 5% discount, or giving you a 3% discount, or I depend that of the rent for living. If you put on the record that you are not unduly benefiting and that you are trying to renegotiate, you have a lower likelihood of getting an injunction against you. But if you have too much of a harsh position, like if you don't try to renegotiate or don't show that you are being also affected by the crisis, is more likely that the other side will convince the judge. So pretty much going to the court is right now at this moment, it mostly depends on how you document your case. And that's why I urge you to, if you're a businessman, to involve your in-house counsel or external lawyers to help you to put the right thing, because there are subtleties of Brazilian law. They are very different from common law. Like I'm also licensed to practice in New York, and the common law jurisdictions are more attached to the four corners of the agreement without too many implied obligations. But under civil law, we have this implied obligation of good faith that's embedded in the fabric of our legal system. So the more good faith that you show in your behavior, the more likely that you will win the case. But that's a strategy for the short term. In the long term, it all depends if you go to arbitration of the judicial courts. That makes a lot of difference, because when you have those big case, and there are statistics saying like the amount of lawsuits already increased from 5 to 10% due to the COVID-19 crisis. Brazilian legal system, you might know, like you have state lower courts, or have circuits for the federal courts, and then you have STJ, that's the higher court for non-constitutional matters, and you have the Supreme Court for constitutional matters. Those cases of COVID-19 case will probably end up at the STJ. In STJ, sometimes they decide cases, they will have the binding precedent not in 1 year, but probably in 5 years, 10 years. And when they have, it's a quite slow court, but when they decide to take into account not only the black letter of the law, but also the public policy implication. So it's very difficult to foresee right now how the STJ will decide those cases of force majeure and hardship. In some parts of hardship and force majeure, they're still debatable under Brazilian law. For instance, the requirement that Giuliana mentioned on the need of the defendant to be unduly benefited, that's the classical test of hardship under Brazilian law, but there are some low court precedents that disregards this requirement. Will STJ disregard this requirement or not? We don't know. We will know in 5 or 10 years. So that's why I say that the important thing right now is for you to get an injunction, whether you're the claimant or the defendant. And for that you need to have a very good contract management. That's for judicial courts. There are other chunk of cases that will go to arbitration. Most business cases will go to arbitration. Arbitration is much faster. If you get to the Brazilian institutions, the average length of an arbitration is from 15 to 18 months, compared to a decision in STJ, as I said, it will take like from 5 to 10 years. And you pick the arbitrators, like you cherry pick the arbitrators. And under Brazilian law, there are 2 different views on civil law. There are some scholars and practitioners that have a more a view that will allow a broader review of contracts. So certain arbitrators would allow a broader contract review in extreme case, like in COVID-19 crisis. And in the other set of arbitrators, will have a more conservative view, a view more closer to what the view of a common law arbitrator, and they will think that the contracts have to be performed as they were written. But there's a clash between those 2 views in the arbitration community, so you have to be very careful when you select your arbitrator. You have to be represented by lawyers that know the arbitrators and know to which club, like to which standpoints such arbitrator will be affiliated. It's also important to point out that there is a trend in Brazil for a lesser review of contracts. The Civil Code of 2002 introduced the concept of objective good faith and many ancillary obligations that allow a broader review of contracts. But it is the Congress that was elected in 2018 is doing several reviews on legislation to make our legal system closer to common law system and to give more prominence to the black letter of the agreement, to the 4 corners of the agreement. So last year there was a law called the Economic Freedom Law that changed the civil code and restricted some aspects of interpretation to force the judges and arbitrators to follow more strictly the four corners of the agreement, the literal wording of the agreement. The Congress passed a law that was like a special and transitory regime that also restrict the issues that could be subject to hardship. But the problem that we had is that most of the articles on civil law were vetoed. But that shows a trend on the Brazilian law. And I'm part of a commission that's changing the Brazilian Commercial Code. And we also have a more, a view less friendly to contract review. So I'd say that the trend in Brazil is to restrict the possibility to review contracts, but we don't know how the courts will decide on those cases. So
Joaquim, sorry to
pass the word to Gledson.
Yes, I will stop you because you know you and me, we love to discuss about contract interference and how the courts and arbitrators interfere in the contract. So if we start talking, we never stop. So let's pass the word to Gledson. Sorry to interject, Joaquim, and thank you for your brilliant words. So Gledson will speak a little bit about judicial reorganization in Brazil. So Gledson, please feel free.
Thank you, Giuliana. Thank you, everybody. And I promise to be fast, or try to, because of time. I will, let's say, if I'm able to share my screen. First, to present an overview regarding our legal system, and then mention some, let's say, modifications arising from the COVID. Our law that provides for bankruptcy, it's quite new. It was enacted in 2005, so have 15 years. It's a completely new, based on the US. So there is some institutes that was indeed copied from the US law and from the German law. This Brazilian bankruptcy law provides for three types, indeed two types of mechanism to the debtor to surpass the economic crisis, and one for the termination of the company, which is the bankruptcy. The first one is what we say, the extrajudicial reorganization. It was the pre-package in the US law and in Canada as well. So this pre-package, it's a debtor restructuring comprising negotiations between the debtor and its creditors. So in practice, the debtor and the creditor agree new terms and conditions for payment, and there is a contract. As long as the advantage in the extrajudicial organization is, as long as a quorum is reached, and the law provides that 60% of creditors that sign agreeing with the contract is reached, the debtor may seek enforcement of these new terms and conditions to the 100% of the creditors. So once there is a negotiation, there is an agreement, and 60% of the creditors agree with these new terms and conditions, the debtor is allowed to go to the court and request the extension of these new terms and conditions to 100% of the creditors. We have as well the judicial organization. So the judicial organization is the Chapter 11. And it's expecting to have a peak in the judicial organization request in the next months. We believe that we will repeat 2016, which was the peak in the history in the numbers and related to the numbers of the judicial organization request. We believe that we will be very close to such peak. We do not believe that we can exceed or this peak because there's some requirements provided in the law to request the judicial reorganization. And one is that we have to, the judicial organization is not possible to request within 5 years term. So if you request today, once it is finished, you have 5 years to wait in order to request a second judicial organization. And we believe that there is no enough time between the crisis in 2016 and now. So we believe that we will have a huge number, but we will not reach the peak. In general terms, what the judicial organization is similar to the extrajudicial, is some kind of agreement, but this agreement is have more a judicial control. So this agreement is named in the extrajudicial reorganization a plan. Such plan must be presented by the debtor. So it's the debtor. Here in Brazil, it's some kind of, it's different from the US law and Canada law. The debtor is entitled to present the plan. The creditors are not. Creditors can suggest, amend modifications, but we have to have the debtor's consent in order to be included. Otherwise, it's not possible to have an alternative plan, for instance. Such plan will provide for the new terms and conditions for the payment, will describe how the creditor, how creditors will be paid, which assets, for instance, must be sold in order to pay, which will be the mechanism or the proceeding for the sale in order to avoid any kind of succession. Of course, the law paid a lot of attention in relation to the mechanism because the law realized that we have to assure to the buyer that there is no succession risks in order to have someone interested in acquiring an asset. So we have several judicial decisions stating that there is no succession. As such, decisions were confirmed by the Superior Court in Brazil, STJ confirmed there is no succession. We had this, for instance, at the very beginning of the law. So the first company that used the new law in 2005 was Varig. Varig sold some assets, and such discussion arose in the Superior Court, and the Superior Court confirmed that there's no succession. And we have also the bankruptcy, and the bankruptcy is the liquidation of the company. So once a debtor realized that it's not possible to continue doing business, the bankruptcy is the alternative. And the bankruptcy is the liquidation of the company. And one thing that it is important to consider in the bankruptcy, and it's a difference from the judicial and extrajudicial. There is an order of payment in the bankruptcy, and there is no order of payment in the extrajudicial and the judicial. Payment in extrajudicial and judicial will follow the terms and conditions provided in what was negotiated and what was approved in the plan. Of course, the plan must be in the extra and the judicial. The plan, which is the document, must be presented to creditors. If there is some kind of opposition, must be a subject to a general creditors meeting, approved, and there is a quorum for approval, and must be ratified by the judge. So we have several steps in order to have a plan approved. Such plan there is no order, so the plan there's some let's say parties are almost free. There is just in relation to labor creditors some kind of rule, but parties are almost free to establish payment conditions, and the courts already decided that there is no a plan is not null and void due to what is negotiated in relation to economic conditions of the plan. So the courts will not analyze the economic conditions of the plan. Debtor and creditors should discuss this, and once it is approved, courts are prevented to reanalyze such terms and conditions. And then bankruptcy, as I mentioned, there is a payment order. So first, we have labor. There is a limited 150 minimum wages. Then you have creditors with a security, tax, some kind of privilege, and then unsecured creditors. So there is an order, and the importance is you pay the following order just in case the previous one is 100% paid. And I bring here some what arises from the COVID. There is no amend in the law. We have here just up to this moment, and I think that we will not have any new law enacted because we are almost 4 months in quarantine. So what we have until this moment, and I think that we'll continue having, is a recommendation by the Brazilian National Council of Justice, Conselho Nacional de Justiça, and this kind of recommendations follows the common sense. So what is based is, first, there is a pandemic, so we have to avoid having meetings with several people. So what the recommendation is stating is the creditors, general creditors meeting are suspended, but the judge must realize it by electronic means, which is it's important, and I think that will be a good effect from the pandemic if this rule is followed from now on. And the judge, what the Brazilian Council do as well is to, let's say, to ask to the judge or to suggest to the judge to receive amendments in the plan regarding postponed payments, because the economic effect of the pandemic may affect the debtor. And so what the recommendation is saying is that it is allowed or it is possible to have amendment of the plans or postponement on obligations. And we have also a bill of law, which is still subject to approval in the House of Representatives. Have approval from one of the most important or approved in one of the most important committees, and then if it is approved, such law has some new requirements, and I just had to highlight one, which is important to the companies. This law or this bill of law here is providing for a moratorium. So every debtor in this country will have the possibility to postpone the obligations for 60 days. Of course, there is for obligations matured after March 20, which is the day which is declared the pandemic here in Brazil. So for every and all obligations mature as of such date, it's possible for debtor to claim for moratorium automatic without any kind of or without presenting any kind of reason. It's automatic, and it's possible to go to the court and to request additional period for more 60 days. But then, in order to obtain such additional period in court, then you have to present document that we have at least a reduction in 30% of your revenue. But then I think that it's a very important role, because if it is applied, I believe that based on what happened here in Brazil, and I'm very sad to say that I'm quite sure that almost 100% of the debtors will take advantage from such rule and request postponement of its obligations in 60 days. And we can have a collapse here in our system if such rule is applied. So I think that I finished, and I open for questions.
Thank you, Gledson. Thank you, Joaquim. Thank you, Giuliana, for your presentation here today. Since we're a little bit over time, we do have one question here that is in Portuguese, and I don't know if my legal English is good enough to translate. So I don't know if Joaquim, if you wanted to kind of read the question and see if you can answer that one, please.
Okay, it's saying that the use of expert to analyze contracts makes arbitration close to judicial courts. What we see is that arbitrators tend to have more, to be more business oriented than court judges. Court judges, especially from the SCJ, are pretty much concerned about public policy and to have consolidation of the case law. Whilst arbitrators are normally practitioners or renowned scholars, and they will be more friendly to considerations on contractual balance and economics of the contract. But as Giuliana well said, the best thing, if you are afraid of reviewing a contract, and unfortunately, if you're talking about hardship, you might end up reviewing the contract. It's better to go to mediation or to renegotiation, because then we'll have control on the outcome. Delegating that to a judicial court is not good at all, because the calculations will be done by a court expert. Juliana also explained that. Arbitrators are more knowledgeable of economics, but they're still they are not as good as the parties. Like, let's remember, like the famous Pareto, Italian economist, that said that the best economic outcome is the outcome that the parties negotiate by themselves. Like in my view, any judicial review of a contract is quite risky, no matter if it's done in arbitration, where the judge has a better comprehension, but still is not as good as the parties.
Thank you, Joaquim. Well, so since we are like a little bit of overtime, I would like to thank all our panelists for their time and availability to join us here today. If you have any further questions on this subject, please feel free to connect with Gledson, Giuliana, or Joaquim. They'll be happy to help. We will add their contact information on our website together with the video of this webinar that will be posted in a couple days. So again, we would like to thank also our annual sponsors, Vale, Brookfield, Landing Mining, and Votorantim Samari Cement for their support. We hope the information shared here today was fruitful and relevant for your business. And we ask you to please keep engaging with the BCCC, download our app, follow us on social media. We have a lot of other events coming up in the next few weeks, and we'll be happy to have you there. So for any questions or concerns, please feel free to connect with us as well. And I would like to thank you all for being here. Have a great day, stay safe, and we'll see you all very soon. Joaquim, Giuliana, Gledson, muito obrigada. Thank you very much for your time.
Thank you, Carolina.
Thank you.
If you guys need anything as well, we're here to help. Thank you so much, and have a great Tuesday, everyone. Thank you.